Leading our discussion, as he often does, Carter Clay of the firm Wright. Good to see you, sir.
Good to see you. Looking forward to our discussion tonight.
It's going to be an interesting one.
Well, it always is, but certainly tonight we're going to be talking about estates, wills, trust, what you need to know, what you need to do before a loved one passes away and after a loved one passes away. It's not the most stimulating topic, but just like death, it's inevitable that when you die, you've got assets and they have to be disposed of one way or the other. And the question ultimately becomes, do you want to control how your assets are distributed or disposed of, or do you want to allow the state of Alabama to make that decision for you? And to help us navigate our way through the discussion tonight, we have Peter Wright. He is an attorney here in the Birmingham area with Sirote and Permutt, a long-standing, well-established law firm here in the area. Peter does a great job for his clients. He represents a lot of clients. If you have questions about how to dispose of your assets, whether you need to set up a trust, what your will needs to look like, Peter is the guy to speak with. We're privileged to have you on the show here tonight. Thank you for being here, Peter.
My pleasure.
Tell the viewers a little bit about yourself, what your practice consists of, and we'll just kind of jump right into it.
Sure, be glad to. I'm at the firm of Sirote and Permutt, full-service firm, A to Z. We've got offices in Huntsville, Birmingham, and Mobile, as well as in Florida. And I'm a member of what's called our estate planning department, and we have about 15 lawyers in the estate planning department, most of them doing planning work, and that is actually drafting wills and trust and helping people prepare for the future. I actually work in the estate planning department, and I always tell folks sometimes I'm the person you don't really want to see, because I deal a lot with the estate administration process and sometimes the estate litigation process. And so I'm dealing with the probating of wills with the courts, and oftentimes dealing with some family disputes as well.
Let's bring this up just right off the bat, because I don't want there to be a misconception of the viewership in that, well, I clearly don't have enough assets to warrant hiring somebody like Peter Wright or a law firm to dispose of my assets. Tell us a little bit about it. I'm assuming you've kind of got a wide range of income levels and wealth levels relative to your client base. Is that fair to say? I mean, should people be turned off or discouraged from even listening further simply because they don't think they've got enough assets?
No, and to some extent, if you handle your assets in a way of using joint accounts and some other financial measures you can take to try and avoid probate, you can do such things. But generally speaking, the range of income is not going to be that critically important in regard to getting a plan done. It is particularly important for those of higher wealth because of estate tax and tax issues. But even those of lower wealth, if I can use that term, it's critically important. And as you we have discussed, it's critically important to have that control over the disposition of your assets. And also it's critically important to have that plan so you can prevent misunderstanding, confusion, family disharmony in many cases. And sometimes even with a plan, that family disharmony can still happen in my business. So.
Right. You brought up probate. Help us understand, what is probate court?
All right, let's talk about probate court. Is a special court over at Jefferson County Courthouse. It's in every county in the state.
Okay.
And that is where you go after someone dies and there is a will, and you can take the will up there with filing appropriate petitions with the court to have that will probated and become the official will of that decedent, that deceased person's estate. And after that will is probated and a personal representative is put in charge of the estate, which can also create some strife as to who is going to be in charge of the estate, but that will be also part of the probate process. And then it goes through an administration process with the probate court that has to last for at least 6 months period of time. You have to notify creditors, you have to deal with payment of bills, and ultimately you get to the conclusion of that administration process after that 6 months period, and you disperse the assets and you have a final settlement of the estate. And that is with a will.
Right.
Now you can also be up at the probate court where you don't have a will. And where you don't have a will, those are called intestate estates. And It goes through a lot of the same process. You file a petition, someone has to be appointed to be in charge of the estate, and you still have to deal with creditors.
Right.
You still have to disperse the assets, but you don't have a will to tell you how to disperse the assets. You have some laws that tell you how to disperse the assets. All states have these laws of distribution, and those laws of distribution will help guide you on how you divide up your estate, usually among your next of kin.
From a definition standpoint, how would you define a will? Kind of help us understand, in case some folks. Let's just start from the basics, and we'll work from there. But
Sure.
For a smart legal fellow like you, what is a will?
Well, a will is a legal instrument that one signs, like this is my last will and testament, and sets forth one's, lack of a better phrase, dying wishes of how they would like their property disposed of.
All right.
And that is probably the easy definition, but it also is important because it can speak to who they want to be in charge of the estate. It can also be important whether you're going to be setting up special provisions under the will, like a trust that can be set up under a will, where sometimes for planning purposes, you may want your assets not to go directly to David and Carter. We may want to put it in trust for David, and maybe we'll let Carter have his outright. But we may want to put David's in trust, and you can use a will for such planning purposes, if you will.
With the will, is there any uniformity of what every will should contain? Are there kind of requirements?
Yeah, there are, and I probably should have touched on that, but absolutely, it does need to be in writing. It does need to be signed by the testator.
So it has to be in writing, so a video?
No, they're not in Alabama, we'll say. And there are some states that can recognize even verbal wills, oral wills, but not here in Alabama. But it has to be in writing, signed by the testator. Testator has to be 18 years or older, has to be of sound mind. And now you're getting into my area, and also has to be free of undue influence, where some of those issues come into play. And from a basic standpoint, importantly, it needs to be witnessed by two people, and it has to be witnessed in a special manner in order for it to become a valid, binding will. And when you have a will, you take all of that up to the courthouse with your petition, and the court and the judge and or parties involved in the case are going to be looking at all of those requirements to make sure they are met.
Sound mind, you hear whenever wills are contested in the media, oftentimes it's sound mind is called into question, or it is contested in some way. Is that just a Hollywood thing, or are those bones of contention oftentimes?
Well, in my area, I see it just about every week.
Do you
really? Sometimes I have, families that come to me and they say, "My gosh, I have to tell you my story." And I said, "Well, ma'am, you are not alone." We do see it a lot. Our firm does a lot of trust and estate litigation. And you're right in that you've hit the two top areas, and that is testamentary incapacity, having sound mind to understand and appreciate the will, and also what were the circumstances of the will? Was there undue influence involved? And the law can be pretty heavy in getting involved in that area.
We can pick up right there whenever we come back. We're going to take our first break of the evening. As we do so, a reminder of how you can join the conversation. You can call us, text us, email. Also find the firm of Hollis right there on Facebook as well as Twitter. Stay tuned. More of the attorneys coming right up. Welcome back in to the attorneys. Also love the one about the pet owners. Got to include those pets in there. Talking about wills and such tonight on the attorneys, and would love to have you to be a part of the conversation. You can call, text, email your questions in to us.
Peter, when we took the break, we were talking about undue influence, and I'm going to imagine that a large part of your practice involves dealing with individuals who are suggesting or asserting that the decedent was not of sound mind or body, or was unduly influenced by perhaps their brother or sister in executing the will. Do you see that quite often?
That is by far the largest portion of my business. It really is dealing with wills that are subject to questions of mental capacity, what they would call testamentary capacity, number one, and that is, did the person have the capacity to appreciate that it was a will, know their assets, and have a full understanding and appreciation of who their next of kin, or the natural objects of their bounty is what we call it in the law. That has to do with testamentary capacity. And that is, the law recognizes that elderly persons don't have to have perfect capacity, okay? And so it's not whether you have a bad day, but it's really whether you have the failure to appreciate the will and or the natural objects of your bounty. So those cases are, you don't see it as prevalent, I'll say. Undue influence are much more prevalent, and that is the situation where you may have an elderly person who is of diminished capacity and who is being, classic case would be a caretaker. Caretaker has come in and has been, and I'm going to give you the bad side of it, okay? There's plenty of good caretakers out there. Let's be crystal clear about that, and I'm grateful for them for my clients in many cases. But there are some bad ones, and when they get involved in a close relationship with a person of diminished capacity and become the more dominant party, and then there become beneficial transactions, i.e. a piece of real estate goes to the caretaker, an account goes to the caretaker, millions of dollars go to the caretaker. It creates, and it happens in an environment of undue influence, and those are ripe for litigation and lots of questions and immense emotions, as you can imagine.
And in the caretaker context, I'm imagining or envisioning a situation where you have that kind of setup and a family member sort of comes in after the fact or in the 11th hour and finds out that assets had been diverted to the caretaker or that a will had been changed, and the blood relative obviously doesn't find that to be very appropriate, and they challenge the transactions that have taken place. Is that typically how it evolves?
That really is, you've hit it on the head again. That's the most prevalent, in that they will find out after the fact, oftentimes, after death. Sometimes you will see some signs of it before a death occurs, but it's usually after death. And so in those situations, the family members are dealing, sometimes mourning the death, and then they have to deal on top of that with some bad acts that may have occurred. And and I talk about immense emotion. It really is emotional time, and people can be very angry and very emotional and have to deal with that and have to handle the litigation and the lawsuits properly to contest the will or whatever it may be.
And the situation could be even worse when you've got one sibling accusing another sibling of undue influence.
Correct, and it's not just caretakers. Sometimes it is often family members, fighting amongst themselves, and it's a classic case we see a lot when one family member is doing a lot of that caretaking work and doing good caretaking work and developing that close relationship, but even with a father or an uncle or an aunt of diminished capacity, when those questionable transactions happen, they again become, I'll say, ripe for questions and oftentimes ripe for litigation, and that is a large part of what I see over in undue influence world.
We got some good questions coming in. A question here: what are some things that can cause a will to become invalid?
All right. Well, when we are looking at causes of action to invalidate a will, we really focus on three areas. We've kind of talked about all three of them, but first area, what I would describe as the formalities of the will. Just were they 18? Were they of sound mind? Was it properly signed? Was it properly witnessed? Were those basic formalities met under the law? Sometimes they're not, and a lot of details and technicalities can come into play. But those are pretty rare. Second is what we just talked about, is did they have the testamentary capacity? Did they have the capacity to understand the will, understand what the property they have, and understand the natural objects of their bounty? That's a legal term that really means their next of kin, who is naturally supposed to receive this property. And that's not a high threshold. It's kind of a low threshold, if I can speak generally about it. But that's the second avenue typically that comes into play when invalidating a will. And then the third, again, the most prevalent, is was the person subject to undue influence of another when it came to the execution of the will and handling of the procurement of that will.
So if a family members believe a will is invalid, will they be able to contest it?
Yes. When you say family members, from a legal standpoint, it would be the next of kin.
Okay.
And that's going to be typically a mother or father, or grandmother, grandfather passes away. The children are always going to be next of kin. And sometimes, if you have children, aunts and uncles don't even come into the mix in regard to a next of kin and or a right to be notified about the will process, and oftentimes whether they have even a right to challenge the will as a next of kin. Now, you can also challenge a will if you are upset with a new will, but there was an old will, and so you are the uncle or aunt. It may not be the child, but you are the uncle or aunt, and you were named under the previous will, and here comes this new will, and they will have standing to contest in that context where they have standing under an old will. But without the old will analysis, it really comes down to the next of kin, and the typical scenario would be the children.
All right. Let's take our second break of the evening, final break. In fact, as we head to break, I want to remind you of how you can be a part of the conversation. Call us, text us, email. Also find the firm of Hollis Wright. They are easy to find. Search the term Hollis Wright on Facebook. You can also find them on Twitter. It's Hollis_Wright to find them on Twitter. Stay tuned. The final segment of The Attorneys coming right up. I think you're used to that here. Welcome back into The Attorneys. Appreciate you being with us. Just a few minutes remaining, but time enough for you to get your question to us. Call, text, email, and bring that question to us. We'll pass it along to our panel.
Peter, we touched upon this a little bit earlier, but I want to specifically address property that can be disposed of or prepared for disposal outside of the will or the probate process. A lot of times in the wrongful death context, which is where I get involved in having to deal with probate and estate matters, somebody might own a house or have a banking account. What can individuals do who don't want to spend the money to have a will probated or to distribute money? Are there certain assets that can be handled jointly?
Sure. Let's take the example of just sort of some principal asset. Well, let's start with the house and an account. Say your estate consists of that. You have a house and you have all your financial assets in a small checking account or a large checking account, and you want to avoid probate. Well, in the case of the house, by deed, you can clearly establish by deed that the house is joint tenancy with right of survivorship, which is jointly owned, and typical example would be a husband and wife, and if I die, I leave it to my wife under what's called survivorship, so that at my death, it would go automatically to my wife without any need to go to probate court. Same thing with an account. You can have an account, say it's at a bank and it's titled jointly in the name of the husband and wife, joint tenancy with right of survivorship. When you have that survivorship language in there, it will, as a matter of law, direct that the funds that are left in that account in my example, my death, would go automatically to my wife. No need to have to go to probate court and to have it flow by a will or to have a will admitted. It would go automatically as a matter of law. A couple of other examples. An insurance policy are typically set up, I'm sure you're aware, with special beneficiaries designated. And when a death occurs on a life insurance policy, that asset flows directly to that life insurance beneficiary without any need to go to the probate court. We describe it as passing outside of probate. And so that would be another asset that you can handle. I'll say in a rare occasion you will have an insurance policy that will be paid to one's estate, which we don't view probably as a good planning technique, because you have an insurance policy, then you got to go back to the probate court and flow it through your will. And cars can be, automobiles can be handled in the same way, although the Division of Motor Vehicles often will recognize a surviving spouse to receive a vehicle upon presentation of a death certificate and sometimes with an affidavit as well.
Logistically speaking, though, should the widow, even though she automatically takes the house, shouldn't she, I guess, have a new deed drafted that then makes her the sole owner of the house?
You can, and that gets into a little bit of real estate area. You can, you do not have to, because it's automatically vested in that surviving widow in our example as a matter of law. But for clean title purposes, she can certainly easily arrange for a new deed as well.
About out of time, but I would love for you to give a final charge, kind of a final tip for our viewers tonight.
Sure, I'd be glad to, because you know, I've talked with business owners and families about this, and this is going to sound mighty simple.
Right.
But when it comes to dealing with these estates and one's assets, and particularly where you have family businesses involved, what I always try to tell people is to think hard, particularly for the father and mother patriarch of an estate, to think hard about communicating with your loved ones before death, because it can save an immense amount of time and money after death.
Agree with that real quick?
Communication is the key, no doubt about it.
Yes, no doubt about it. Do it and do it. Go ahead and have that conversation tonight. We appreciate you being with us. Thank you, the both of you all as well. Appreciate the conversation. Here's how you can continue to get in touch with the firm of Hollis Wright. Easy to do so. Also find them on Facebook and Twitter. We're out of time, but we'll see you next week right here on The Attorneys.